Friends, this is Parmanand Pandey. I'm an advocate practicing in the Supreme Court of India and other courts of Delhi. In fact, we have been running a blog that is called Judicial Panorama, but now we have started the videography of our blog, wherein we will be discussing different topics relating to law and other matters. Today we are going to discuss about the NJAC, which is raising a controversy across the country. There is a dispute which has been raked up by the Union Law Minister Mr. Kiran Rijiju, as well as by the Vice President of India Mr. Jagdeep Dhankar. Apart from it, on the Constitution Day of the 26th November 2022, there were many voices which came from different corners of the country saying that we must have the NJAC in a different form so that the defects which were there in the earlier NJAC could be removed and we can have a new foolproof NJAC which can give the best competent, fair judges to this country. It does not mean that today the judges are in fact not competent, but the fact is that the way the selection of the judges has been made in this country is considered to be not fair by most of the people. The people say that the nepotism and some sort of casteism, regionalism, another type of corrupt practices are adopted by the judiciary for the selection of the judges of the higher courts. That is why there is a need to have a system which can give us the competent as well as good judges selected through the objective means, by the fair means, and they should be able to inspire the confidence of the people of this country. If that is so, then the judiciary will be able to enjoy the prestige, the honor, the respect of the people which it has been enjoying earlier. The fact is that from 1950 onward, we have had a system where the executive has been selecting the judges to the higher judiciary, that is to say in the High Court and the Supreme Court. But after 1993, the collegium system was adopted, whereby the executive has been reduced to almost zero, and the collegium which recommend the name of the High Court judges or the Supreme Court judges are to be accepted by the executive, and therefore the executive finds itself helpless. The executive can do only one thing, that it can sit over the files for some time in the name of getting it investigated, in the name of getting the report from the CID about the persons who have been chosen as the judges of the High Courts and the Supreme Court, and whose names have been recommended by the Collegium of the Supreme Court. This, in fact, has been getting the criticism from different corners of the country by the different sections of the society. They say that India is the one and the only country where appointment of the judges are being made by the judges themselves. Therefore, there is every chance of nepotism which must go away just to inspire the confidence among the people for the judiciary. It must be stated here that under Article 124 of the Constitution of India, there is a word, in fact, which says that the selection of the High Court and the Supreme Court will be done, judges of the Supreme Court and High Court will be done by the consultation of the Supreme Court Chief Justice of India by the President of India. Thereafter, it was argued by most of the people that what does the consultation mean? In 1982, there was a case, in fact, namely S.P. Gupta versus Union of India. That case was heard by very eminent judges of the Supreme Court. That case dealt with the word consultation and concurrence. The, the decision which was delivered by the Supreme Court at that time was that consultation does not mean concurrence. Consultation means if the President of India is consulting about the name of any person to be elevated to the post of the High Court judge or the Supreme Court judge, he or she cannot be or cannot necessarily be appointed as the judge of the High Court or the Supreme Court. Well, it will have to be seen by the President of India or by the government of the day whether the person whose name has been given by the Chief Justice of India will be acceptable to us or not. So they say that the word in fact is a consultation. So it was later on in fact it was interpreted that consultation means concurrence. Whatever is being said by the Supreme Court has to be accepted by the President of India. That means the consultation, in fact, the word becomes redundant and the consultation will be interpreted as the concurrence. Whatever is said by the Supreme Court will have to be concurred by the President of India, and the President simply becomes a signing authority. That is the purpose of the that is the purpose which in fact has been interpreted by most of the people of this country. But the Supreme Court in that judgment said, no, consultation does not mean concurrence. Concurrence, in fact, those who say that it is a concurrence, no, they are wrong. The President of India, in fact, has only to consult, and consultation does not mean that it will be binding for him. It will not be binding. It can be rejected, it can be accepted. That is the purpose of the consultation. The second, in fact, point of that decision was that the judges of the High Court can be transferred from one High Court to the other High Court, even if the judge, in fact, is agreeing to that transfer or not. This has to be made final, that whatever the decision is of the President of India about the transfer of the judges, that has to be binding for that judge. This is the S.P. Gupta's case gist. Thereafter, in fact, after almost 10 years, after 10 years, another case arose that is known as the Supreme Court Advocate on Record Association case. In that case, it was said, no, consultation means concurrence, and whatever is recommended by the Supreme Court has to be binding for the President of India for the appointment of the judges in the higher judiciary. That gave the birth to the collegium system, and that collegium system, it was said that whatever is said by the President of India, will not be binding. In fact, it is the Chief Justice of India who recommend the names will have to be binding. Thereafter again, the third judge's case came, and in that case, that is the reference case by the President of India, which was sent under Article 143. And in that case, the collegium system was evolved. It was not, in fact, made limited to the President, Chief Justice of India. It was made that for the selection of the High Court and the Supreme Court judges, a collegium will be made, and in that collegium, the Chief Justice of India will be there along with the 4 other senior most judges who will, in fact, recommend the names of the judges to be appointed to the Supreme Court. So, in fact, it made a lot of controversy. People started doubting over this system, and they said, no, it will not give rise to the fair selection, and it will not inspire confidence of the people. That is the reason that in 2014, the Government of India thought of introducing the National Judicial Appointments Commission. The National Judicial Appointment Commission's purpose was to appoint the judges of the High Court and the Supreme Court. And in that National Judicial Appointment Commission, it was made that the minister, in fact the legal minister of law, and two senior most judges of the Supreme Court, including the Chief Justice of India, and two eminent persons having legal knowledge, will be forming a committee, and that committee will scrutinize the names for the judges, for the appointment of the judges in the High Court and the Supreme Court. That NJAC was challenged in the Supreme Court, and the Supreme Court struck down, saying that no, the old collegium system of having 4 + 1 Chief Justice of India plus 4 senior most judges will be acceptable, and the NJAC's proposal is being rejected. That will be undone. That has been set aside. Now again this controversy has arisen. Now let us see what will happen. It is all in the store of the future, whether the government will go for an improved version of the NJAC or it will continue to accept the collegium. But as of now, the collegium is in the operation. And so friends, this video was on the collegium system, for which in fact the entire country is discussing. Now in the next video we will take up some other topic, and I hope that you will give the benefit of your opinion to us so that we can improve our videos on the different legal issues, which will be useful to you and to the legal community, to the students of law, and whosoever is interested in the legal affairs of the country. Thank you.